Back at the Zondo Commission of Inquiry into State Capture, the former Eskom board member and acting CEO at Eskom, Wilfred Zethembe Khoza, says the appointment of Dudu Mayeni's former consultant, Nick Linnell, was imposed on the board. He says Linnell was not supposed to be on the power utilities payroll as he was placed as a presidential resource. He's also reaffirmed he did not have any relationship with Salim Essa or the Guptas when he was asked to respond to claims about involving the Guptas in protecting the former Eskom CEO Matsela Koko from being suspended. Khoza was testifying before the Commission on the suspension of Eskom executives in 2015.
You didn't ask as the board before using him. On the 11th, you didn't ask, Mr. Tsotsi, have you followed procurement processes?
When he introduced him, he said he was given resource by the presidency. Mm-hmm. And he has been looking at the parastatals, mm-hmm. and he's got lots of documents that he's sitting with. Mm-hmm. So he was not the person who was supposed to be employed by, at the time. My version of understanding at the time was that he was not going to be employed by Eskom.
Yes.
But however, he was going to be used as a resource that came from the presidency.
Yes.
But later, it was not the fact.
Yes.
Because then it was then he was supposed now to be seen as a consultant.
Yes.
That now is helping us on the process.
But you didn't seek to have any confirmation about him being employed by the presidency or appointed by the presidency or being somebody who would be paid by the presidency as at the 11th, isn't it?
No, at the 11th it wasn't.
Yes.
But I think as later, because it came up on a very hot meeting and tense situation that was there, and he introduced him in that space.
Yeah.
And he was going to deal with certain issues. At the time, then nobody asked the questions. And I think after that, then people start following it up. Then it was realized that it did not come up correctly. So it was just being imposed on us.
Yes, well, one, you, Mr. Tangoban and Ms. Klein didn't say what you are saying. When this was put to them.
Well, on Friday, the Judicial Conduct Committee of the Judicial Service Commission will hear closing arguments in the case to determine whether or not the Western Cape Judge President John Hlophe tried to improperly influence Constitutional Court judges in a case relating to President Jacob Zuma back in 2008. Here on Newzroom Afrika yesterday, you saw Judge Hlophe answering questions from the evidence leader in the case and from the lawyers representing the majority of judges at the Constitutional Court at the time. This issue has been dragging on for over 12 years. Romeo Ntembaleni is a legal analyst and an advocate. Mr. Ntembaleni, good afternoon to you. So, firstly, after 12 years, finally this matter is reaching an end. Well, I optimistically say it's reaching an end. How important is it to get a clear resolution to this? And by clear, I mean where everyone finally knows and accepts what really happened.
Thank you, and good afternoon, Stephen. I think, like you've correctly indicated, the matter has been dragging on for quite some time, and I think it should reach its finality after what we have seen transpiring recently. Finally, the commission sitting and sort of going through the evidence and the information on whether the judge president indeed tried to influence the other judges, his colleagues, and the court who were working on the former president's cases. So 12 years is a long time, and it took longer than expected. And we believe that hopefully, as you have indicated, this will be the end of the matter, and the matter will finally be laid to rest once and for all.
I mean, the other possibility, of course, is this: there's a finding by the Judicial Conduct Committee, and one of the parties involved, and there's several parties, decides to go back to court to review that. I mean, it may not be the end of it. And even after the Judicial Conduct Tribunal makes a ruling, it's got to go to the Judicial Service Commission for a final ruling. I mean, there are two steps that could be reviewed by judges. There are at least 6 possible court cases.
Indeed, it's a long process, like you're actually indicating. And if it doesn't go that way, also we must remember the issue of Parliament. That if there is an impeachment proceedings that are recommended against the judge president, it has to go to Parliament, and there must be a sitting in Parliament to decide on the proceedings and who is supposed to actually chair that. So indeed, there can be review proceedings, long proceedings, and all these legal processes, they take quite longer time. So it might actually drag on for quite a bit longer, because when you have those kind of processes that are still yet to be finalized, obviously looking at the person of Judge Hlophe's caliber, I don't think that if there's any finding against him, he will just not take it lying down. He might actually review it, and it might take longer to resolve.
There was the site yesterday. Now, I've never seen this. There was Judge John Hlophe, Judge Chris Jafta, Judge Besson Kabinda answering questions put to them by lawyers. We see it sort of when judges are appointed, but in this case, they were being asked lawyers in what is really a sort of adversarial situation. It was quite something to watch. Now, does it show that our judges in our democratic system are accountable, or could it, contrary to that, risk lowering the respect that we as a society should have for judges?
No, not in my view, Steve. I think it was quite an important exercise to actually show some sense of accountability on judges, because we could on indicating that judges are appointed in terms of the Constitution under Section 174 and 175 respectively, and we say that judges are not above the law and no one is above the law. So I will argue that was actually a good site for the society to show all level of accountabilities for judges and judicial officers, and it sets a very good precedent for our democracy to indicate that indeed judges are accountable for their actions, and they are not above the law. So I think it's an appropriate time, Steve, to actually address this situation in that manner, to say that it's a good precedent and it ought to be followed. If you can call a president to come, or even a former president to come and account before a commission of inquiry, a judge is not an extraterrestrial being. They are supposed to be questioned if ever there is an inquiry of that nature that is sitting. So it's good for our law.
It's an excellent point you make. I don't see how anyone could argue against it when you bring in the Zondo Commission. I do want to sort of raise another thing. Now, my grey-haired memory is sort of old enough to remember the first Judicial Service Commission hearing in this case. And then the finding was to sort of clear Judge Hlophe, but to not subject anyone to cross-examination. It was all behind closed doors. I was a much younger journalist then. We basically sat outside doors and waited for people to come out, and none of them would talk to us. Yesterday, we had all of this appearing in public. I mean, live here on Newsfeed, we saw judges being asked questions. And you know what? The sun still rose this morning. The world did not cave in. Civilization as we know it did not come to an end. And the point that I'm making is that it would seem to me to raise serious questions about the original decision of the Judicial Service Commission as it was constituted at the time, I'm talking a decade ago now, to not have cross-examination. It would seem to me that shows that their decision then was a mistake.
Yeah, it was totally incorrect. And as you've correctly pointed it out, Steve, I think the issue of transparency is very, very much important. And the tone need to be set by judges themselves. And if they are open to scrutiny by the media, it shows everyone that there's nothing to hide. So it's an exemplary move that was taken, that this should be aired for everyone else to see, and people should make their own determination and make their own minds to decide whether there is any modicum of truth in the allegations that are brought before the inquiry. So the opening of an inquiry is a good process, and it supports the processes of the Constitution.
We're going to see another case involving Judge President Hlophe in a couple of weeks. Now, also before the Judicial Conduct Tribunal. In that case, and it's a bit more complicated, it's alleged he assaulted another judge. And again, this is about judges in conflict with judges. And the Deputy Judge President of the Western Cape, Judge Patricia Goliath, lodged that complaint against him. And this raises the question, is there any reason why our judges should not be able to get on with each other? I mean, we have this amazing situation in the Western Cape bench where 10 judges have said they won't sit and hear cases with the judge who Hlophe is accused of assaulting. And Judge Hlophe then said that he would take action against any of those judges for not actually obeying his decisions as judge president. I mean, this simply, no matter where it all started, none of this should be happening.
Indeed, Stephen. What we need to actually make clear is that the judges owe their allegiance to the Constitution. That's why they take their oath of office and swear under Schedule 2 of the Constitution. And to actually defy a judge president is not only unconstitutional, but it's also unlawful. It doesn't matter what kind of cases the judge president is currently facing, but if you are given the responsibility and you don't execute that responsibility, you yourself failing to execute that responsibility is opening yourself up for an inquiry at the Judicial Service Commission against your conduct of not actually administering the justice the way it's supposed to be administered. Because imagine if you and me, Steve, have a case and the judge can't hear it because it doesn't like the judge president, and the administrative justice system is impacted and adversely by such kind of conduct of the judge. And let's not forget, Steve, that the Constitution also applied to judges to say that everyone is innocent up until they are proven guilty. So you must apply that presumption of innocence even in a difficult case as such as the one of the judge president, until he's found innocent or he's found guilty by an inquiry or even the court of law, as we've indicated that it might actually be a process that end in the court of law. And the most important question that we normally ask under those circumstances, Steve, is who will judge the judges? Because these are the judges themselves, and we have indicated that they're not extraterrestrial beings. They had to be judged by someone who's independent, who is not biased, who will apply only the law and the Constitution. So their colleagues are equally competent to actually judge them. There were a lot of other suggestions that were raised that perhaps maybe judges from other jurisdictions can be borrowed to come and deal with issues that involves judges themselves. So that could work as well, because we are indicating that these judges know each other, they are colleagues, and the other one, if he knows the other judges, will ask to be recused. And you might find that instead of the matter being settled early and be heard and proceeded before court, it takes longer to actually find competent people, or you even have to move to a rank of retired judges to come and actually assist in dealing with the conduct of judges against each other.
I suppose we lend judges to so many other countries. I mean, Namibia, Eswatini, Botswana, including the United Nations from time to time. It's about time someone lends us a judge. Judges are meant to arbitrate disputes in our society, and we're seeing them dragged into politics more and more. I mean, the Khoza case, unfortunately, did involve politics at the time. Now, judges are also being asked to resolve disputes when they don't want to be involved in politics. I mean, there have been cases involving the internal politics of the ANC, the internal politics of the PAC. Are we going to find that the risk of this, despite the best efforts of the judiciary, is that some people just won't respect judges? The judiciary as a whole becomes seen as political, even when judges are trying desperately not to have to hear these cases.
Indeed, Steve, I think you've given a very good example. I think the Chief Justice has indicated that previously, the current Chief Justice, Mogoeng, to say, the political parties must themselves try and resolve their own issues with their own internal processes, and coming to courts should be the last resort. But that's not what we have seen playing out, because the internal processes of political organizations have failed, and then it ended up playing out in court. You can give example of COPE, you can give example of PAC that you have actually given, wherein you have seen that their matters ended up being resolved by the courts, agent applications from the Northwest, and the likes of the ANC. So the good thing about courts resolving the political issues is that the courts, when they resolve political issues, they apply the law, Steve. That's what the judges apply. And then the law should be applied without favor, without fear, and without bias. So that's why you see that a lot of people in political organizations rather resort to take their matters to court when they were not resolved in their political organizations. And in one way or the other, a resolution is found in court. As an example that we've given in the leadership of COPE and other political organizations as well.
Romy and Timbaleni, I really appreciate the time. Thank you. Legal analyst and advocate with you here on News.